So we're live now. Good evening, everybody. We all are here for the last leg of our SCAORA lecture series for the AOR exam aspirants. Today, we are honored to have Singh sir, senior advocate, who will be delivering his lecture on the leading cases. Sir will be discussing a part of the 64 cases which are there in the list, and this lecture is being live broadcasted on YouTube. Anybody who has any questions can put the same in the chat box and they will be taken at the end. Before we start, I would like to give a brief introduction about Sir. C.U. Singh Sir is a senior advocate practicing in Supreme Court of India. Sir was a late entrant to the practice of law. Having earned a bachelor's degree in commerce, he started out by returning to his agriculture roots and ran a crop farm in Punjab, followed by a small dairy and milk supply business in Haryana and Delhi. He then worked as a journalist in Bombay for the India Today's magazine. During his first 4-year stint in that magazine, he earned his law degree from Government Law College, Pune. He was later on enrolled in 1984 and subsequently designated as a senior advocate in 2005. In 2009, he shifted full-time in the Honorable Supreme Court of India, and he's appeared for a broad array of cases ranging from constitutional challenges like Article 370, reservation for the Marathas, public causes like the Aadhaar challenge, national anthem case, LGBTQ rights, and a challenge to the beef ban in Maharashtra, to employment law matters, and of course to a lot of commercial cases as well. He's a regular counsel also for the Securities and Exchange Board of India. So I would request Sir to please start his lecture. Over to you, Sir, now.
Good evening, everybody. Time is limited, so I'll get straight into the subject. I have a list of about 21 cases. Might not be able to cover all 21 today, but I will do my best to at least give you a glance into the most important of the judgments of these out of this list of leading cases. The first aspect which is in my list deals with minority education, minority educational institutions, and minority rights vis-a-vis education. Let me open straight away with the 11-judge bench judgment in TMA Pai Foundation versus State of Karnataka. Now, this 11 judges judgment came about because ever since Unni Krishnan and certain other judgments, this issue regarding what extent of control there can be on minority-owned educational institutions, it had gone up. Ahmedabad, St. Xavier's, it was, I think, a 9-judge bench. It had gone down to 7 judges benches, 5 judges benches, and over a long period of time, there was a great deal of uncertainty because there were conflicting judgments of large benches of the Supreme Court over what extent of control there could be on minority educational institutions. So ultimately, this whole Jingbag and Kaburu got referred to an 11 judges bench when Justice Kirpal, Justice B.N. Kirpal was the Chief Justice of India. And Justice Kirpal, in fact, authored the main majority view of 6 out of the 11 judges. Justice Kirpal spoke for himself and 5 other learned judges, and then some of the other learned judges concurred or partly dissented. So let me straight away get into TMA Pai Foundation. This is 2002, Volume 8, SCC 481. And a few of the essential features of this judgment, or the essential points which have been decided. So taking a cue from earlier judgments in Ahmedabad, St. Xavier's, and in especially in St. Stephen's College, etc., the first very important point which the bench decided in TMA Pai was that that there has to be a certain degree of regulation and control would necessarily be exercised even in respect of minority educational institutions, despite the protection given to minorities to establish and administer educational institutions of their choice under Article 30, under Article 29, but particularly under Article 30 of the Constitution of India. in spite of that, the view always taken was that some degree of control has to be there to ensure the quality of education, and to ensure that the quality of education is not such that it actually harms even the members of the minority by giving them such a poor education that the children of that particular community may grow up being deprived of a true education. So as a consequence, there was always this dichotomy between what extent of control can there be for the purpose of ensuring the quality of education, and where does the state have to be hands off and say that where does the court say that thus far and no further, the state can't encroach on certain minority rights. So the first thing in the judgment, in the majority judgment penned by Chief Justice of India Kirpal on behalf of 6 of the learned judges, himself and 5 others, at page 578 of the report, paras 136 and 137 are very important because he pithily summarized the view which was taken in earlier judgments, which is that the right to administer under Article 30 does not include the right to maladminister. In other words, minorities are given a right, a fundamental right to administer education, to establish and administer educational institutions of their choice. But that does not mean that they can maladminister them. They have to administer them for the benefit of the community and for the benefit of the children at the end of the day. So para 136 and 137 specifically upheld, the bench took the view that the right to administer is not absolute and it must be subject to certain reasonable regulations for the benefit of the institutions as a vehicle of education, consistent with national interest and consistent with the interest of the children. So laws pertaining to health, morality, standards of education would apply notwithstanding Article 30 or Sub-Article 1. They said that right is not unqualified, and those regulations which are for the purposes of standards of education and so on would apply. Those which are for the welfare of students, and especially those which are for the welfare of teachers and staff. For instance, protecting the pay scales and so on of teachers and staff, ensuring that teachers and staff are not treated, like slaves or like indentured labor and so on. Those laws again would be treated as valid, and so paras 136 and 137 give you the answer to this. Ultimately, Justice Kirpal answers the 11 questions which were framed by the court, and this, you can make a note of this, and it's worth reading these answers to the 11 questions, which you'll find at page 5, starting at page 587 of the report, are the answers to 11 questions. This is para 162, and this contains very elaborate and detailed answers which run to, almost about 8 or 10 pages, 10, 12 pages. So the first answer was that what is the meaning, the content of the expression minorities in Article 30? They said that it includes linguistic as well as religious minorities, both, but that the unit for determining minority status would be the state, because our states were set up on linguistic basis, and therefore it is not that all of India should be taken as a unit to determine whether somebody is majority or minority. It would be in a state. In other words, say Hindi might be the majority spoken language in most of the states, but in several states where the majority of the states speak another language like Odia or Bengali or Tamil or Marathi or Gujarati, the Hindi educational institution might be a minority educational institution within that state, even though overall on an all India basis they would be part of the majority language. Similarly, with religions also, religious minorities would depend on the makeup in each state. This is the first important thing. Then the question was about whether professional education also gets a protection of Article 30, and the answer to that was yes. Professional institutions, the minorities have a right to set up not just educational institutions for younger children and going up to the degree level and all, but even professional colleges, which are medical colleges, engineering colleges, etc., can be set up. Then they held that so far as unaided minority educational institutions are concerned, those which take no state aid at all. In their case, the scope of interference by the state in the choice of students, in the admission process, in the number of admissions which they give to minorities, etc., would be very, very minimal. In other words, the state can't interfere in the completely unaided minority institutions, because there they are not only exercising their rights under Article 30, but they're also not seeking any aid from the state. They're not seeking any monetary assistance from the state, and therefore they get a much greater degree of latitude and freedom. Then, with regard to admissions of students in aided schools and colleges, etc., it was pointed out it was held by the court. Sorry, even for unaided, they said the procedure must be fair. Procedures laid down for admissions and the standards which are adopted by them should be fair and reasonable, and they should be transparent. Then, so far as where their aided institutions are concerned, the majority held, the court held that there the state, because it's giving aid, the state would have an ability to also regulate to a much greater extent the use of the aid, and they could lay down conditions in the grant of aid and so on. Whereas in unaided minority educational institutions, the regulatory measures would be minimal, they could be much greater in the case of aided institutions. Interestingly, the bench said that with completely unaided institutions, that is, they said there is actually no difference between minority and non-minority institutions. If you're seeking no aid whatsoever from the state, from the government or from government bodies, then you should have total freedom to regulate your own affairs, and also, of course, subject to looking after the teachers, morality, health, and all those other sort of issues. So far as unaided institutions are concerned, they also said that the fees which are charged by unaided institutions cannot be regulated by the state at all, but the fees charged by aided institutions can be regulated. This was a broad view taken by the 6 learned judges. Justice Kadri, Justice Rumapal, Justice Varyawa and Bhan partly dissented on certain points and partly agreed on certain points. But the judgment remained a judgment of 11 learned judges, subject to certain small areas of dissent and so on. So this was the view taken in TMA Pi Foundation versus State of Karnataka. This then led, there was a further churn after this, because in the case of soon after TMA Pi came, some of these questions again came up before a bench of 5 learned judges in Islamic Academy. And Islamic Academy took a view that the state can, by picking picking and choosing certain words from TMA Pi, and perhaps some words were picked out of context, they said that a great deal, so far as fees are concerned, so far as choice of students are concerned, and most importantly, so far as the state imposing quotas on a minority educational institution, Islamic Academy took the view that the state has a great deal of power to impose quotas and to ensure that not only the minorities are admitted, but others are also admitted, and so on and so forth. As a result of that 5-judge bench, that got referred to a larger bench of 7 judges in PA Inamdar, and PA Inamdar is in your syllabus. PA Inamdar versus State of Maharashtra is 2004 8 SCC 139. And this was a bench of 7 learned judges. And as I said, it came up about because Islamic Academy misinterpreted certain parts of TMA Pi. Now, ultimately, in this 7 judges bench, it was a unanimous bench, if I remember right. Chief Justice of India, R.C. Lahoti, I think, spoke for the bench. And he clarified, this bench clarified what TMA Pi had actually held and where Islamic Academy had gone wrong. So if you, this judgment begins at page 530, the PA Inamdar is the citation which we have here at serial number 2 is actually a referring judgment, if I'm not wrong. So please note down the correct judgment, which is the 7 judges bench. That is 2005, Volume 6 SCC 537. 2005, Volume 6 SCC 537. This is the actual 7 judges bench judgment. And the judgment begins at 2005 6 SCC at page 537. At page 599 are the answers which are given. I'm not going to trouble you with going through the reasoning and all. The answers which ultimately come, 4 questions were framed by the court in PA Inamdar, and the answers are from 599 onwards. The first question was that whether in uneducated educational institutions there can be an appropriation of quota by the state, and whether the state can enforce the reservation policy. The court broke this up into 3 parts. In the first part, they dealt with minority educational institutions which were neither aided nor recognized. That means they sought neither recognition or affiliation, nor did they seek aid. They were simply minority educational institutions run completely by the minority concerned, without any affiliation, without any recognition, and without any aid. In their case, the court held that they are absolutely free to admit all students of their own minority community if they choose to do so, and state cannot regulate that part at all. They can't impose quotas, they can't impose reservations on an unaided, unrecognized minority institution. The second part they dealt with minority unaided educational institutions, but which had asked for affiliation or recognition. Like you want to be part of Central Board of Secondary Education, or you want to be affiliated to a university, etc., etc., etc. So you are not seeking aid, but you're seeking affiliation or recognition. Here the court said that the essential ingredients of freedom would still remain, subject to that they would have to ensure merit. Their rules and regulations would have to ensure merit, because they are seeking affiliation and seeking recognition from the Board of Education or the university and so on. And so in para 121, the court dealt with unaided educational institutions of the minorities, but which were seeking recognition and affiliation. And the court said that there have to be, their standards have to ensure merit, excellence of education, and to prevent maladministration. So they said the state can make provisions for the quality, to indicate the quality of the teachers, to indicate minimum qualifications for teachers, to indicate the courses of study, the curricula, that to indicate that the infrastructure of the institution is sufficient for the grant of recognition or affiliation, etc. But no interference in day-to-day administration, and no quotas and all could be imposed on them also. The third category, they said, minority educational institutions which are receiving state aid. So here are now minority educational institutions which receive aid. Here the court said that following TMA Pi, aided institutions would be, whatever standards are laid down for grant of aid to others, those particular standards for grant of aid would also apply. But the court made it clear that these institutions were not before the court in this particular case, so they were not giving the final verdict on that aspect. So as far as seat sharing and quotas are concerned, in para 124, the court made it clear that even in aided minority institutions, the state cannot insist on seat sharing or imposition of quotas or imposition of reservations on them. Para 122, 124 and 125 of this judgment are very important in that regard. And ultimately, they disapproved of Islamic Academy in para 130 of the judgment. So this is as far as PA Inamdar is concerned. We next come to serial number 4 is Pramati Educational and Cultural Trust, but the side note says that this is replaced with Society for Unaided Private Schools of Rajasthan versus Union of India. So if you see Society for Unaided Schools of Unaided Private Schools of Rajasthan, the citation is 2012, Volume 6 SCC, page 1. 2012, Volume 6 SCC, page 1. Now, this judgment came about in this manner that after Unni Krishnan had said that there's a directive principle of state policy that primary education has to be given to all. Pursuant to that Unni Krishnan judgment, the court started directing the government in certain cases that you have to frame a policy to give primary education to all. And ultimately, the parliament itself amended the constitution and they inserted Article 21A. So they moved the directive principle from a directive principle, they moved it into a fundamental right. And Article 21A was inserted in the constitution, which said, which was a right to education. And Article 21A said that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. Now, this fundamental right having come in Article 21A, ultimately pursuant to this, the Right to Education Act 2009 came to be framed by the then government, by Parliament in the year 2009. Some of the provisions of the Right to Education Act imposed considerable liabilities on private educational institutions, including unaided private educational institutions and including minority educational institutions. So what they did was they said that, for instance, 25% of the intake of the school has to be of people who are poor people living in the vicinity of the school, and they would have to be given free education by the schools, and so on and so forth. There were several such provisions in the Right to Education Act. These were challenged by a bunch of private unaided schools of Rajasthan, as well as a huge swathe of institutions from all across the country. I had in fact appeared for boarding schools, for certain boarding schools which stood in a class apart, and ultimately the Supreme Court said that boarding schools will stand in a slightly different footing from the others. But the three-judge bench presided over by Chief Justice Kapadia took the view 2:1. They negatived all the challenges, saying that even though Article 21A said that the state shall provide free and compulsory education, the state could do so even through private schools, and the state was offering some amount, though the compensation was very, very negligible what was offered. But they said as long as the state has offered some compensation to the schools for giving free education, the schools have to give free education to the primary school students up to from the lower prep till the 7th standard. That is, from the lowest grade to the 7th standard, the entire from the age of 6 to 14 years as per Article 21A. So, so the majority here of Justice Kapadia and I forget who, Justice Kapadia and Justice Swatantra Kumar, they negatived virtually all the challenges and upheld the law in its entirety, except, as I said, with regard to boarding schools, they made an exception. And except for one small aspect which they struck down, and that was with regard to 12(1)(c) and 18(3), with regard to unaided minority institutions. They said only in case of totally unaided minority educational institutions, this imposition of giving free education over and above that to others, that would not apply. So they struck down that particular provision under Section 12(1)(c) and Section 18(3). Justice Radhakrishnan was in a minority. He partly dissented with them, but the judgment is the judgment of the majority naturally prevails as a three-judge bench judgment of our court. Now, I'll next go straight to the issue of tribunals and the independence of the judiciary. Now, if we look at the sort of the development of law here, I'll just give you a brief outline and then go straight into the judgments which are in your syllabus. Basically, over the years, tribunalization came about, and initially we had tribunals like in industrial tribunals and tribunals for various things, but from all those tribunals, judicial review used to lie to high courts under Article 226 or Article 227 and to the Supreme Court in not just under Article 136, but even in a case where fundamental rights are violated under Article 32. Now, when in the 42nd Amendment of the Constitution, what happened was that Articles 343A and 343B were introduced in the 42nd Amendment, which took away judicial review completely as far as the high courts were concerned, and also the Supreme Court under Article 32, and said that the decisions of these tribunals could be final and they could only be challenged under 136 before the Supreme Court of India. So this ultimately comes up, it first came up in the case of L. Chandrakumar versus Union of India. Again, I must tell you that in the syllabus, what is set out, the citation is of the referring judgment. This 1995 1 SCC 400 at serial number 5 is the judgment making the reference. Ultimately, this was decided in 1997, volume 3 SCC 261. 1997, volume 3 SCC 261 by a bench of 7 learned judges of the Supreme Court. So the L. Chandrakumar judgment which we are concerned with is 97 3 SCC 261. That is the actual judgment of 7 learned judges. Now, what was held in this in Chandrakumar's case was that one sec, just give me half a second. Yeah. So this was a unanimous judgment which was penned by Chief Justice of India, Justice Ahmadi, and the view taken earlier, prior to L. Chandrakumar, a 5-judge bench had, in the case of Sampath Kumar, the 5-judge bench had held that, upheld the validity of these amendments, and had taken the view that Articles 343A and 343B were valid, and that judicial review was rightly done away with in those in that particular case. The judgment of SP Sampath Kumar was reported in 1987, 1 SCC 124. Then this was certain benches disagreed with this and asked for a reference to a larger bench, and that is how it came before a learned 7-judge bench in L. Chandrakumar. Now, Chief Justice Ahmadi, essentially, and just in a nutshell, speaking for a unanimous bench of 7 learned judges, he held that the power of judicial review over legislative action is an integral and essential feature of the Constitution, and that it constitutes part of the basic structure of the Constitution. The basic structure of the Constitution you are all familiar with was laid down in Keshavananda Bharati. And so in L. Chandrakumar, what the learned Chief Justice, speaking for the bench of 7, said that judicial review over legislative action is an integral and essential feature of the Constitution, and it constitutes part of the basic structure. He held that ordinarily the High Courts as well as the Supreme Court have the right to test the constitutional validity of legislation, and that right can never be ousted or excluded, because to oust or exclude that would be violative of the basic structure. Sorry, I said 343A. It's Article 323A and 323B were the 2 articles under which which were introduced by the 42nd Amendment. So ultimately, the court holds that to the extent that Article 323A, sub-article 2D, and Article 323B, sub-article 3D, empowered the Parliament and the state legislatures to totally exclude the jurisdiction of all courts except that of the Supreme Court under Article 136, they would be completely unconstitutional, because a constitutional amendment which seeks to alter the basic structure of the Constitution is something which is impermissible after Keshavananda Bharati, after the Keshavananda Bharati judgment. The Supreme Court took the view that the power of judicial review vested in the High Courts under 226 and 227 and under the Supreme Court under Article 32 could not be curtailed by a constitutional amendment, including 323A and 323B. And therefore, they struck it down. Now, consequently, what was the various laws like the Administrative Tribunals Act 1985, which said that there will be no challenge before the high courts and all those provisions were read down by the Supreme Court, and it was held that those provisions were, which completely excluded the jurisdiction of the High Court, were bad at law. So this is where the view taken by Chandra Kumar. But what is important is also, though we are concerned only with the leading judgments here, but what has happened after that is that in practice, more and more laws have come which have given an appeal to the Supreme Court. And while giving an appeal to the Supreme Court, while they do not expressly exclude the High Courts, but the view taken by the courts, including the Supreme Court, has been that since you have an alternate efficacious remedy of an appeal, the High Courts would normally not exercise their powers under 226 and 227. So this is what has then happened with a large number of tribunals that you have, whether it is under the Securities Appellate Tribunal, under the SEBI Act, the APTEL, and under Electricity Act, or TDSAT, etc., etc., etc. All these tribunals, National Green Tribunal and all have appealed to the Supreme Court. So though judicial review remains, that judicial review to the High Court remains, it remains more or less on paper, except in cases where, a tribunal might not be available or something of that sort. So to a large extent, the notwithstanding El Chandra Kumar, the position which we have on the ground is that the position which you have on the ground is that it is more or less you get relegated to the sole remedy of going to the Supreme Court of India. The next judgment is Roger Matthew. Now, Roger Matthew is a constitution bench judgment of 5 learned judges. And here the question was that what should be the appointment process for these tribunals which are set up as substitutes for high courts, and whether persons who are not qualified to be judges of a high court can be appointed, and whether the executive alone, that is the executive branch of government, can take over the control of appointments to these tribunals and so on. And ultimately, what was held in Roger Matthew, Chief Justice Gogoi spoke for the bench, which consisted of Justice Ramana, Justice Dr. D.Y. Chandrachud, Justice Deepak Gupta, and Justice Sanjeev Khanna. Though there were also supplemental judgments by Justice Chandrachud and Justice Deepak Gupta, but Justice Gogoi basically spoke for the entire bench, and his conclusions ultimately were, of course, there's one aspect regarding money bill and all which we need not be concerned with, but they said that the tribunal, appellate tribunal, and other authorities' qualifications, experience, and other conditions of service of members rules 2017, which were under challenge, suffer from various infirmities which are impinging on the independence of the judiciary. And since these rules had been formulated by the central government under Section 184 of the Finance Act, being contrary to the parent enactment and to the principles envisaged, principles of constitutional interpretation and judicial review, etc., interpreted by the Supreme Court, they were struck down in their entirety. So the entire rules were struck down, and the central government was then directed to reformulate the rules strictly in conformity with R.K. Jain, L. Chandra Kumar, Madras Bar Association, which was a very important judgment, which was in 2010, in 2014, 10 SCC page 1, and the Gujarat Urja Vikas, etc. And then in that basis, they should have conditions of service for chairpersons and members of tribunals, which ensure the independence of these tribunals from the executive. So they would have to have the rank and status equivalent to judges of high courts or judges of the Supreme Court, as the case may be, and they would have to have independence from interference by the government, and so on and so forth. Then there were certain other things which were safeguards which was laid down. in Roger Matthew. This was more recently followed by another judgment of the Madras Bar Association, which is at serial number 7 of your list in the syllabus, that is Madras Bar Association 2020 SCC online. Now, this is also reported in the main SCC, so you can take it down. It's 2021 7 SCC 369. 2021 volume 7 SCC 369. And this was Madras Bar Association is a judgment of 3 learned judges of the Supreme Court, authored by Justice Nageshwar Rao. And here they really distilled all the previous judgments, including Union of India versus Madras Bar Association 2010, Madras Bar Association 2014, and Roger Matthew, and all the others. And they looked at the process for appointment of the tribunals, and how a chairman, president of a tribunal, what sort of search selection committee has to be there, what sort of eligibility criteria have to be laid down, and so on and so forth. So there's this judgment again. It basically carries forward the legacy of L. Chandrakumar, Roger Matthew, and importantly the 2 earlier Madras Bar Association judgments. 2010 was Union of India versus Madras Bar Association, was a 5-judge bench judgment, and 2014 was the one which Justice Gogoi referred to in Roger Matthew, which is 2014 SCC page 1. And so Justice Nageshwar Rao basically lays down in a nutshell what are the standards which are to be met in order to ensure the independence of tribunals, and what what safeguards are required, and what will be an infirmity in the setting up of such the manning of tribunals. Then here they went into great detail as to what allowances should be given, what sort of pay should be given, house rent allowance, this, that, and all. So it's a very detailed judgment which goes into the sort of granular details, of how this independence of tribunals is to be ensured while making appointments and so on. So this deals I think brings me to an end to this aspect of the tribunals and per se tribunals and independence of the judiciary. Serial number 8 is though it's in this section of independence of the judiciary, but it's a very interesting judgment, but on a completely different subject actually. Serial number 8 is Bar of Indian Lawyers through its president Jasbir Singh Malik versus D.K. Gandhi. This is a recent judgment of a bench presided over by Her Ladyship Justice Bela Trivedi, and with her the concurring judgment is also delivered by Justice Pankaj Mittal in this particular case. Now, what this judgment was dealing with was not independence of judiciary at all. This judgment deals with whether the Consumer Protection Act whether it was intended by the Consumer Protection Act to cover lawyers and the services that lawyers render to their clients in the strictly professional services which lawyers render to their clients in their capacity as advocates, enrolled with a bar council and so on. Now, in this judgment, the court actually broke it up into 3 aspects. The first they said was that the 3 questions which arose were: 1, whether a complaint of deficiency in service within the meaning of Consumer Protection Act 2019 is maintainable against an advocate who is rendering services to the client as a lawyer. 2, whether the services rendered by a lawyer to the client are sui generis, are in a class by themselves, whether they are sui generis and they are totally different from the services rendered by any other class of service provider to their clients, including other professionals. So whether the services rendered by a lawyer are sui generis, and 3, whether the services rendered by a lawyer in any case come within the frame of a contract of personal service and are thereby excluded anyway, as contracts of personal service are excluded from the Consumer Protection Act. So they broke it up into these three points. And what ultimately Justice Bela Trivedi held, that professions are completely different from other services, which are like maybe a barber shop or a repair service or a service of providing a band service or some such thing, as opposed to services of professionals, because they say services of professionals require advanced education and training and a great deal of learning and science in a particular skill. And the skills are involve specialized kind of mental work which operate in specified spheres, and achieving success depends on many other factors beyond a man's control. And therefore, a professional cannot be treated equally or at par with a businessman or a trader or a service provider of products or goods as contemplated in the Consumer Protection Act. So, first of all, the Supreme Court holds, Justice Bela Trivedi holds, that all professionals are actually not covered by the Consumer Protection Act. So her view was that lawyers, along with other professionals like doctors, architects, etc., might not be covered by the Consumer Protection Act. However, the bench was faced with a three-judge bench judgment in the case of Indian Medical Association versus VP Shanta, where the three-judge bench had taken the view that doctors are covered by the Consumer Protection Act. So faced with this dilemma, the bench said that this first question, that whether professionals are covered by the Consumer Protection Act, we believe that lawyers are not covered at all. But we believe that all professionals are not covered. Since VP Shanta judgment is staring us in the face of a three-judge bench, we request the Chief Justice to constitute a larger bench on this first question. But then the bench goes on to say the second two questions. They say that they hold that a lawyer's services are sui generis. They are in fact sui generis. They fall in a class by themselves, because a lawyer is not just giving a service to the client, but the lawyer is an officer of the court who owes a separate duty to the court, separate from what the duty owed to the client. Secondly, the lawyer is part and parcel of the administration of justice. And since the lawyer is part of administration of justice, which ultimately has to culminate into decisions which the lawyer does not take, but which the courts take, courts or tribunals or authorities take. Therefore, the lawyer is only putting forward a case as part and parcel of that system, where the lawyer is part and parcel of that administration of justice, and therefore they say lawyers are sui generis, in a class by themselves, and therefore in their case, in any case, notwithstanding VP Shanta, the three-judge bench in Indian Medical Association, notwithstanding that, lawyers will stand outside the Consumer Protection Act. They then go on to say that even on the third count, a contract of a lawyer, the engagement of a lawyer with his client, is a contract of personal service. It is not a contract for service as understood in the distinction between contract of service, contract for service. They say this is a contract of personal service. So it is based on faith and trust. This is a contract based on faith and trust and confidentiality and various other factors. And therefore, it's clearly a contract of personal service. And therefore, in any case, under the Act itself, it stands excluded. So all three ways, actually, Justice Bela Trivedi holds that lawyers are to be excluded. But the first point, she refers to a larger bench. The other 2 points, she holds that lawyers are excluded under the Act. Justice Pankaj Mittal gives completely independent concurring judgment. He concurs entirely with her view, but he goes into a very interesting aspect. He goes into the fact that these consumer acts were introduced pursuant to a United Nations resolution to which India was a party, and hundreds of many other countries were parties. He says since these acts were enacted pursuant to a United Nations resolution, and all the other countries that he could study did not include lawyers within the scope of services, he said there should be some sort of uniformity. If you're doing something pursuant to an international treaty and international covenant, then and every other country has excluded lawyers, then it would be proper for India also to follow some sort of uniformity with the rest of the United Nations countries which have enacted these laws pursuant to that. So it's a very interesting hypothesis by Justice Pankaj Mittal. But he, as I said, he concurs on the results with Justice Pela Trivedi. Now that brings me to a complete yet another subject which is separate but is in the same general heading of independence of judiciary. This is serial number 9, which is SBP and Company versus Patel Engineering, 2005, Volume 8, SCC 618. Now, this was a judgment which I won't spend too much time on this judgment, because actually speaking, this judgment has become sort of, though it's part of your syllabus, but it's become it's virtually been wiped out by the march of time because of amendments of 2016 and 2019 in the Arbitration and Conciliation Act. What basically this 7 judges bench was constituted in SBP and Company because in a 5-judge bench in Konkan Engineering held that the Chief Justice of India or the Chief Justice of a High Court, while appointing an arbitrator or arbitral tribunal under Section 11, performs only an administrative task and not a judicial or quasi-judicial task, and therefore those judgments, the orders of the Chief Justice, etc., are challengeable under Article 226. Number one. Number two, they are not judgments as such which bind parties, and they don't decide anything with regard to the list of the between the parties. All that they do is make an appointment of an arbitral tribunal. That was the view in Konkan. Konkan got referred to a 7-judge bench in SBP and Company versus Patel Engineering, and the 7 judges bench, Justice P.K. Balasubramanian speaking for 6 learned judges, overturned Konkan and said that the Chief Justice performs a judicial task, and therefore when the Chief Justice of a High Court or the Chief Justice of the Supreme Court appoints an arbitral tribunal, they are performing a judicial task, and therefore their orders are not challengeable under Article 226, because it's a coordinate judge of the same court is performing a judicial task, and so on and so forth. I believe that this was a very strained interpretation. My personal view has always been that Konkan took the right view. But ultimately, Justice C.K. Thakkar dissented, and his dissent actually is, to my mind, a far more important one in this particular judgment. But the reason I said that this has been effaced by the march of time is because in 2016, Section 11 was substantially amended, and it was made clear that this is pure and simple and administrative task, and that in fact in subsection 6A and 6B were added, 11.6A and 11.6B, etc., which made it absolutely clear that there is no part of the list, nothing is decided by the Chief Justice of the High Court or the Supreme Court, except, or his delegate, except that there is an arbitration agreement. Prima facie, if there is an arbitration agreement, then an arbitrator has to be appointed. So all that they are deciding is the existence of an arbitration agreement, nothing more, nothing less. Even challenges to that arbitration agreement have to be decided by the arbitral tribunal and nobody else. This is what came about in 2016 amendment. Strangely, for some reason, in 2019 amendment, subsection 6 capital A was deleted, and but the Supreme Court in Mayawati trading took the view that, notwithstanding the deletion of subsection 6A, the import remains the same, that the Chief Justice or his delegate performs only an administrative task. Now, what was very important in this amendment of 2016 is that the same power that is exercised by the Chief Justice of a High Court or the Supreme Court can also be exercised by a delegated authority, which is like a trade body or any other body to whom the government or the Chief Justice delegates this thing. For instance, Federation of Indian Industry, FICCI, or somebody might be delegated a power to appoint arbitral tribunals, or some other trade organization can be delegated the power. Now, obviously, if a trade organization can be delegated that power to appoint arbitral tribunal, then when the Chief Justice of a High Court or Chief Justice of Supreme Court does it, or their delegate does it, there's no difference between them and that body. So it's so clear now that the situation which was prevailing when SBP was decided just doesn't exist anymore. So I think that is as far as that goes, that is should be the end of that. That brings me to Mayawati trading. If you'd like to just note it down, Mayawati trading is 2019. Volume 8 SCC 714. 2019 8 SCC 714 is Mayawati trading. Now, I would straight away skip over some of the other judgments because since time is limited, I would like to deal with both the Puttaswamy judgments. The first KS Puttaswamy, which you find at serial number 18 of the list, is the 9 judges bench judgment in KS Puttaswamy, which is reported in 2017, volume 10, SCC, page 1. And this is the judgment which dealt with the right to privacy. And the 9 judges bench judgment took the view that privacy is a fundamental right, and they sort of clarified the earlier judgments, which in the case of Khadak Singh versus State of UP and all, where there was where a 5-judge bench had taken had some indications that a contrary view was taken, but the 9-judge bench judgment, the main judgment in a sense, is that delivered by Dr. D.Y. Chandrachud. At that time, Justice Kehar was Chief Justice of India. Justice Chandrachud's judgment begins at this KS Puttaswamy is 2017, volume 10, SCC, page 1. And at page 345, this head note itself runs into 344 pages. So at page 345, the judgment begins, and Justice Chandrachud speaks for Chief Justice Kehar, Justice Agarwal himself, and Justice Nazir, for 4 learned judges out of 9. Justice Chalameshwar, Justice Bobde, Justice Nariman, and Justice Sapre, and Justice Sanjay Kishan Kaul all rendered concurring judgments, separate concurring judgments. So the 9-judge bench was virtually uniform in the view that they took in this matter, and they held that privacy is a fundamental right, and it is a part of the core values of of our constitution. They held that while Khadak Singh's exposition of right to life was correct, but it is not merely what was held there, but life and personal liberty are inalienable and interconnected rights. They're inseparable from a dignified human existence. Justice Chandrachud's view summary may kindly be seen the conclusions from para 316 to para 328 at page, it begins at page 507. And so he held that privacy is a constitutionally protected right which emerges primarily from the guarantee of life and personal liberty in Article 21, and elements also, certain elements also fall within Article 14, Article 19, etc. But primarily and mainly it arises, it's part of the right to life and liberty in Article 21. He also held that this is a constitutional core of human dignity. Privacy is part of the constitutional core of human dignity, and it is to be put at a much higher pedestal than various other rights also, including informational privacy and various other things. As I said, the concurring judgments are Justice Chalameshwar, Justice Bobde, Justice Rohinton Nariman, Justice Sapre, and Justice Sanjay Kishan Kaul, all of them. One very interesting point which I'd like to make is that it is in this judgment that Justice Chandrachud buried the judgment to which Senior Justice Chandrachud had been one of the members of the 5-member bench in ADM Jabalpur. ADM Jabalpur is the infamous judgment where 4 out of 5, including then Justice Chandrachud, had taken the view that during a period of emergency, all rights, including the right to life and liberty, get completely suspended, and you have no fundamental rights whatsoever. It is in this judgment that from paras 132 to 132 to 141, Justice Chandrachud, in very, very strong and unsparing words, shredded ADM Jabalpur and said that is a judgment which should never have been rendered, and we overrule it once and for all so that it never sees the light of day again. Justice Kaul also in his concurring judgment said that ADM Jabalpur is buried 10 fathoms deep. But from time to time we seem to see some ghosts of ADM Jabalpur rising up now and then. This is as far as the privacy judgment is concerned. The other judgment of Puttaswamy, which was rendered thereafter by a bench of 5 learned judges, is the Aadhaar judgment. That is Puttaswamy Aadhaar is 2019. This is at serial number 17, 2019, volume 1, SCC, page 1. And in this judgment, Justice Chandrachud found himself in a minority here, and he has rendered a dissent. Justice Dr. A.K. Sikri, speaking for himself, Justice Deepak Mishra, who was then Chief Justice of India, and Justice Khanwilkar rendered, Dr. A.K. Sikri rendered the main judgment for 3 learned judges. Justice Ashok Bhushan broadly concurred, though he, in one or two minor respects, he dissented. He gave a very lengthy separate judgment. So 4 judges took a particular view, holding that upholding the Aadhaar system through in all respects, including the fact that including not going into the issue of the money bill aspect. But Justice Chandrachud delivered a dissent, and that dissent is something really worth reading. It is an outstanding dissent. It's I think this will be one of the great dissents going forward. So he held, Justice Chandrachud basically held that the Aadhaar, the manner in which Aadhaar was forced down people's throats was violative of the right to privacy as enshrined in the Puttaswamy 1, that is the 9 judges bench of Puttaswamy, and that it was the manner in which it had been enacted as a money bill was completely unconstitutional. That it was Aadhaar being forced on people, and the Aadhaar data being shared with private companies and private institutions and so on was not just a violation of privacy, but this was it was manifestly arbitrary, because you are sharing private aspects of people's lives and allowing companies to commercialize it and utilize it for commercial gain and so on and so forth. So though the 4-judge bench upheld the Aadhaar infrastructure, the entire Aadhaar Act, the manner in which Aadhaar was forced down the throats of the citizens and possibly sort of implemented, and also the interlinking of Aadhaar with various other rights and benefits and so on. Though they did, of course, say that it will not be used for those benefits which a person has an absolute right to receive, like rations, etc., etc. You can't be forced to link it with Aadhaar. In practice, what has happened is that it has been linked. People are forced to link it. If they don't link it, they don't get their payments. They don't get benefits. They don't get pensions. They don't get access to bank accounts, the KYC system, and so on and so forth. So this judgment, I believe, was a very deleterious judgment. But this is holding the field, and now it's almost become academic, because now 99% or maybe 95% or something of the country seems to be on Aadhaar, and Aadhaar is further linked with their PAN cards, it's linked with their income tax, it's linked with their bank accounts, it's linked with their ration cards, it's linked with everything under the sun. Petrol pumps and here and there and whatnot. So, payment systems, online payment systems, and so on and so forth. So all this aspect to unscramble the egg and unravel this is going to be huge and, near impossible task. So that is as far as Aadhaar is concerned. Then I would like to just very quickly deal with Bomai and Rameshwar Prasad. These judgments, Bomai, which is in serial number 19 and 20, SR Bomai versus Union of India, 1994, 3 SCC, page 1, and which was followed by Bomai, I think, is a 9-judge bench, and Rameshwar Prasad is a 7-judge bench. Basically, Article 356 was the imposition of President's rule. When under Article 356, if the governor was of opinion that there's a failure of the governance and the government is incapable of being carried out, etc., he would make a report to the President of India, and the President, on the advice of the Council of Ministers, would direct imposition of Article 356, which meant that the legislature of the state gets suspended, and all the rights of the citizens which are aired through their elected representatives get suspended, and the central government, in effect, the President of India, takes charge of the state, and so the state then becomes centrally administered as long as that proclamation under Article 356 remains. What happened in Bomai was that Article 356 has been so abused by several states. The President of India, on the advice of the governors of the state, because whichever was the party in power at the center, would use this almost as a weapon when some state was when they were unable to get their will in a state which is ruled by an opposition party. They would impose, on some pretext or the other, they would impose Article 356. So in Bomai, the 9 judges bench laid down they examined the entire history, the legislative history, the parliamentary, the Constituent Assembly debates, etc., and held that this power can be exercised in only certain limited cases where there is actual material, there's concrete and objective material available to show that the factors which are necessary to invoke 356 actually exist. And most importantly, they held that these factors which are cited by the governor in his report are justiciable. They can be challenged in a court of law, and a High Court of the Supreme Court, in their power of judicial review, can examine those factors and see whether they actually exist or whether it is only a ruse or a disguise or a pretext to get rid of an inconvenient government and to impose central rule on a state which is thereby losing its elected representatives and elected legislature. So Bomai goes into it is a seminal judgment. It's one of the most important judgments on constitutional and administrative law, because it extended judicial review into an area which before that had been considered by the Supreme Court to be completely sacrosanct and hands off. That means the courts could not interfere. Once the governor said that this is my opinion, and the president accepted his opinion, that was that. You had to then just wait for that period to get over and a fresh election to be held. Until then, almost nothing could be done by the courts. Bomai says no. And the salutary effect of Bomai, which was then followed about 12 years later in Rameshwar Prasad, where Rameshwar Prasad went further and laid down further, strengthened those principles. The salutary effect of Bomai was that the use of Article 356 dramatically stopped. It became a rare exception, whereas it used to be ruthlessly rolled out every time some majoritarian government was in power, and this happened regardless of the color of the government, whether they were red, blue, white, green, or orange. It didn't matter. Everybody misused this power, but after Bomai, that misuse was significantly curtailed. So these two are very, very important judgments on constitutional law, which curb the power of the governor to make these reports. And we saw this when in Najam Rebia, when Arunachal Pradesh government was toppled, in state of Uttarakhand. when that government was toppled under by invocation of 356, the Uttarakhand High Court itself struck it down, and the Supreme Court upheld that and refused to interfere. In Najam Devia, the Supreme Court struck it down and restored that government which had been toppled and so on. So the principles laid down in Bomai have been very, very, very important for the development of constitutional law in the country, and these are two exceedingly important judgments. That brings me to Pradeep Kumar Biswas. This is seat number 21. Pradeep Kumar Biswas versus Indian Institute of Chemical Biology, 2002 5 SCC 111. Now, this was a judgment pertaining to the maintainability of writ petitions under Article 12. What kind of organization does a writ lie against? So what had happened was that in the case of CSIR, long ago in the 1970s, 1974, if I'm not wrong, in the case of Council for Scientific and Industrial Research, which was a council actually set up by the government in the form of a trust, the Supreme Court, a 5-judge bench in CSIR had held that it is not an authority under Article 12, and therefore a writ would not lie against CSIR. Now, that was a grave aberration, and subsequent benches of the Supreme Court would find ways to distinguish it and hold that various other organizations were amenable to writ jurisdiction. But that ghost of CSIR continued to rise up every now and then, and people would be denied the remedy, even though they were dealing with state-run organizations, state-sponsored organizations, state-established organizations, autonomous organizations under state governments or under central government, and so on. So when Pradeep Kumar Biswas got referred to a 7-judge bench, that 7-judge bench, I think Justice Rumapal was the main learned judge speaking for the bench. That bench clarified the law absolutely with clarity, and it is now very, very clear where writ would lie, what are the factors to be seen to see whether an organization is substantially and directly and substantially controlled by the government. And if it is substantially and directly controlled by the government, whether it is financial control, whether it is administrative control, whether it's controlled by appointments and so on, if it is substantially controlled by the government, a writ petition would lie. It would be an Article 12 authority, and a writ petition would consequently lie under Article 226 against that organization, or under Article 32 before the Supreme Court. On the other hand, if there was a peripheral control, that means control because they have to subject themselves to certain regulatory acts, they have to subject themselves to certain controls of the government by virtue of like Societies Regulation Act or Cooperative Societies Act or XYZ, and government has certain other statutory controls over them, a writ would not lie against them. So the demarcations are very, very clear after Pradeep Kumar Biswas, and which are the organizations where it would lie, which are the organizations where it would not lie, which are the organizations which fall within the phrase other authority under Article 12 has been clarified by a 7-judges bench, and that position, which was somewhat ambiguous, has been made absolutely clear. That couple of more judgments I'll quickly deal with because I think we are running out of time. You can let me know if you can just anybody can interrupt and tell me if I'm going over the time too much. I'll stop. Meanwhile, two very important judgments. One is at sheet number 13.
So there's no time limit. Please go ahead. I'm sure the aspirants will be very, very eager to hear you on all the judgments. So there is no time limit. So please take your time.
Oh, okay. I'll at least deal with a few more, which I can.
Please, sir, please.
So serial number 13, we have National Legal Services Authority, NALSA judgment, National Legal Services Authority versus Union of India. This is, we have the SCR citation here, 2014 5 SCR 119. You can also take SCC if you like, if it's more convenient, 2014 volume 5 SCC 438. 2014 volume 5 SCC 438 is NALSA versus Union of India. Now, this, interestingly, this is one of the very, very important judgments that has been rendered by a bench of only 2 learned judges. But it has stood the test of time. This judgment has been there now for the last 10 years, and it has achieved remarkable, transformation in gender justice and in rights. It was a stepping stone in a sense for rights of the gay community, the queer community, etc. It has been a stepping stone for many other rights. But NALSA was Justice KSP Radhakrishnan and Dr. A.K. Sikri were the learned judges, and they rendered an absolutely superb judgment on the rights of transgenders. Those people who, due to physiological features, biological features, psychological features, or due to just their own preference, are unable to live in the gender which they are born in, or the gender to which they are assigned by society, and who aspire or desire or who crave to be in another skin, to be in a in another gender. So transgenders, we had a great, not great, we had an unfortunate tradition of completely othering them and marginalizing them. So you have had communities of hijras and so on who were transgenders, but who were treated completely outside the pale. They were not able to get housing. They were not able to get any jobs. They were not able to get government benefits under and they were ostracized by society. They were ostracized by unfortunately even by their families very often, and so on and so forth. So NALSA filed, the National Legal Services Authority filed a petition, and that ultimately came up. The writ petition came up before Justice Radhakrishnan and Justice Sikri, and they rendered an absolutely amazing judgment, as I said, where they analyzed the whole background of transgenders, of different forms of transgenderism. And ultimately, their lordships held, from para 61 onwards of the judgment, they held that they separately examined, Justice Radhakrishnan separately examined transgenders in the context of Article 14, transgenders in the context of Article 15, Article 16, Article 19(1)(a), and Article 21. And he held that each one of these articles gave them rights to be treated in a non-discriminatory manner, and to get access to the rights and benefits which every other citizen of India has, including the right to vote, the right to access public services, the right to get government benefits, and so on and so forth. So para 61 and 62, their lordships held that Article 14 would clearly apply, and non-recognition of the identities of hijras and transgenders denies them equal protection of law, leaving them extremely vulnerable to harassment, violence, sexual assault in public spaces, at home and in jail, and also by the police, molestation, rape, forced sex, gang rape, etc., etc. And they said because they are not recognized, therefore these things are happening to them. And that non-recognition violates Article 14. They held that Article 15 and 16, which prohibit discrimination against any citizen, including on the ground of sex, would be clearly violated, because 15(2)(a) gives access to shops, public restaurants, hotels, places of public entertainment, to the use of wells, tanks, bathing ghats, roads, and places of public resort. None of these can be violated by on the ground of sex or gender, and yet transgenders were denied all these benefits. So their lordships held that every one of these, and they also said that Article 16(2), which is that no citizen shall, on the grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for or be discriminated against in respect of any employment or office under the state. They said that to deny a transgender access to a public job on equal footing with others who have a assigned gender that violates 16(2). Now, that's a very, very far-reaching thing, because transgenders after that have been able to compete for jobs in the state sector. It still may be very, very small. They may not be getting jobs. It may be very marginal, but this has opened the doors. It is a right which has been laid down by the Supreme Court, and as I said, this judgment is now 10 years old, and it has held the field. They held under 19(1)(a) that the right to freedom of expression is also available to transgenders. That is violated in the manner in which transgenders are treated. And most important, ultimately, from para 73, their lordships held that Article 21, which is no person shall be deprived of his life or personal liberty except according to procedure established by law. They said Article 21 is the heart and soul of the Indian Constitution, which speaks of the right to life and personal liberty. And they said that this right to dignity, which is available, which is protected under Article 21, is being violated in the case of transgenders. They have to be treated with equal dignity as others. Today, when I went to vote on the 20th of May in Mumbai, I saw that on the forms there are specific provisions. And in the form 17C, which the returning officer has to sign at the close of the polling, the polling officer has to sign after the polling is over at 11 at night or whatever, and give form 17C categorically gives male, the total number of male voters, female voters, and transgenders. Transgenders have their own column now, and that figure is given at the end of the day for every single polling booth in India. So, this has been a very, very important judgment. It is, I think, a judgment really which all of us need to, celebrate. That a two-judges bench of the Supreme Court has done such a great service for the nation. The other very important judgment, again by either a two or a three-judge bench, is the Shakti Vahini judgment. This was a three-judges bench judgment by Chief Justice Deepak Mishra, Justice Kanvilkar, and Justice Chandrachud. Shakti Vahini is here is 2018 3 SCR 770, but if you want the equivalent, it's 2018 7 SCC 192. 2018 7 SCC 192. Shakti Vahini dealt with what are called honor killings. It's actually the most inappropriate phrase, because it's the most dishonorable form of killing. And for some weird reason, we call it honor killing. These are killings, killing of people to supposedly save the honor of the family or the honor of the baradari or whatever it may be. So basically, when people marry out of their caste, when people marry out of their community, when people marry out of their a young couple who choose, who have a free choice, and in a free nation in the 21st century, a country which has been independent for the last 75 years, we've had a constitution for 73 years. In that circumstance, when you have people being killed because of their choice of partner for their life, that was something shocking, and it was being celebrated. And the police were not taking action, and this is happening all over the country. You would have people being killed because a lower caste person has got married to an upper caste person, or and so on and so forth. A person has got married to somebody outside the community or outside the religion, even outside the gotra. I mean, it is something absolutely shocking. So the Supreme Court here took this up, and they rendered a very, very strong judgment, where they said that this is completely unconstitutional, this is shocking, and they laid down a very strong principles to be followed by the police, and the manner in which how honor killings violate the individual liberty, freedom of choice, the perception of the choice of each individual. And Justice Deepak Mishra said that choice of an individual is an inextricable part of dignity. For dignity cannot be thought of where there is erosion of choice. And so he says all these khap panchayats, etc., are completely illegal. They cannot take the law into their own hands, and they cannot impose punishment on people because of their choice of their partner and so on. And then finally in paragraph 55, which is at page 215 of the report, they laid down a series of preventive steps to be taken by every single state government. Then they laid down remedial measures to be taken by the state government. And then 55.3, they laid down the punitive measures which have to be taken. Now, this is very important because this judgment became the sort of building block which led to Tehseen Poonawalla on hate crime, which led to other judgments of the Supreme Court where this vigilante justice is employed. Here is a case where they were trying to give respectability to it by calling them Khap Panchayat and saying that a Khap Panchayat, which is the panchayat of your own community, has sat in large numbers, all respected elderly people have sat, and they have decided that this punishment should be meted out to you, and so on and so forth. So this is the Supreme Court has rightly treated that on par with vigilante justice and said that this is an anathema to our constitutional scheme, and therefore they laid down these three very detailed things: the preventive measures, remedial measures, and punitive measures, laid down in a detailed dissertation in para 55 of the judgment. So that sort of brings me to an end of the main judgment. See, Keshavananda Bharati, Minerva Mills, and Minerva Mills might be a completely, like Asta said in the beginning, is like a subject by itself. All I can say is that Keshavananda Bharati, in a nutshell, laid down a doctrine which has saved our constitutional republic, which has saved our constitutional republic for the last, now Keshavananda Bharati came in 1973, which means that we were only 57, 67. We were only about 26 years old as a nation when Keshavananda Bharati came. Today, another 50 years have passed. And these 50 years, we have had, we have had the emergency imposed by Mrs. Indira Gandhi's government. We've had some very strong majoritarian governments. We've had coalition governments. We've had governments who have tried to bend and sway the constitution this way and that. And as I said, regardless of political color, every government which has, when they find themselves they find themselves in a position of strength, they try to bend the constitution. And it has been Keshavananda Bharati which has prevented this from happening and which has saved the soul of our constitution, saved the soul of our nation. So just to put it in a nutshell, I think that is one of the most, it is probably the most important judgment for preserving the constitutional Republic of India and keeping our nation, safe from a tyrannical, overthrow of the constitution or a tyrannical change in the constitutional framework. It is we really have to thank the judges who formed a slender majority of 7-6 in Keshavananda Bharati. So it was a very, very slim majority, but the slim majority of 1 has, as I said, saved the country for the next 50 years after now 51 years after 1973. I think I'll have to end here. But if there is some possibility to meet up again, of course the exams are imminent, so we may not be able to do that. But I hope I've been able to deal enough with the main, at least the most important out of these 21 judgments.
Thank you, sir. Thank you so much, sir, for such a valuable insight to all the cases, and especially your extra effort to go forward to correct the citations and also to update us about the relevant judgments. Sir, there are a few questions that I would like to share with you. The first question which has been asked is by Mr. Nick. It says that PM Inamdar has not been replaced in the leading cases list as per the notification 2024. Sir, since you're not the examiner, I would suggest that this question need not be answered. The second question, sir, is that it
No,
was
I'll just clarify that I wasn't saying that PA and AMDAR is in the list. I said that not PA and AMDAR is replaced. Pramati Educational and Cultural Trust, serial number 4, is replaced in the right-hand column, replaced with Society for Unaided Private Schools of Rajasthan. So that's the one I dealt with.
right.
Not PA and AMDAR. PA and AMDAR is very much there.
Yes, sir. Sir, the second question which has been asked is that you have mentioned that the citation of 2014-11 SCR 712 is being replaced with 2012-6 SCC 1, but this has been overruled partly by the Paramati judgment. So, do we have to also discuss and study about the Paramati judgment, which has been partly overruling the said judgment?
I think that the examiners will have to tell you, because your index here says categorically that Pramati is replaced with Society for Unaided Private Schools of Rajasthan. The right-hand column says.
Right.
So if it's been replaced, I don't know. The examiners might need to clarify to the aspirants about whether they are to study Pramati or only Society for Unaided Private Schools of Rajasthan.
So we'll take an update and I think we'll forward it.
Yeah, it's at serial number 4. You can just check it up. Asta, you can find out, I think.
Right, sir. Thank you so much, sir. Now I would request our President SCAORA, Sir Vipin Nair, sir, to give a vote of thanks to you.
Sir, it was an absolute pleasure. You had the most difficult lecture of all because of the sheer spectrum of topics that were involved, and you have beautifully capitulated it. And in case that note that you are carrying, it can be shared. It will be great help to others if you feel so. That's different. And so what I feel is I've spoken to some of your friends, and they said that you were a financial and journalist of a very high repute. So after hearing you, it is sure that journalism's loss is our profession's gain. The felicity with which you approach the subject. And one last thing, because when your lecture started, Delhi was bristling with 52 degrees. During your lecture, it has rained. So I guess this is a very good sign for all our aspirants who have heard you and who will continue to hear you. I join all my friends and colleagues in the executive committee to thank you. And also, we will be keeping you occupied after the vacations. We will have master classes and you can address us. And best of luck to all the candidates, and my colleagues here are also here. I hope you all enjoyed this series. This is the last lecture and we closed with one of the best in the business. Thank you, sir.
Thank you. Thank you very much.
Thank
you all. And I wish all the aspirants, good luck and do go there and work hard and do really well at the exam.
Thank you so much.
Thank you, sir.
Thank you very much, sir.